Welcome friends. We have started this channel called Corporate Laws Galaxy. You know, galaxy means group of stars, and every star represents different laws. And we are starting with a series on frequently asked questions on very interesting topics of corporate laws. And we are inviting you, all of you, to also send your queries in our comments column in our video, and we will certainly take up those queries also in our videos. And now I will request you to please share, like, and subscribe to our channel. Thank you so much.
Namaskar. Sir, I have come across a frequently asked question from our professional colleague regarding provisions of corporate social responsibility, that is CSR. Sir, in this context, please explain us that if a company spends more than the requirement provided under section 135 of Companies Act 2013, can that excess amount be set off against the mandatory 2% CSR expenditure in succeeding financial years?
Yes, definitely. The excess amount spent on CSR can certainly be set off against the required 2% CSR expenditure up to the immediately succeeding 3 financial years, subject to compliance with the conditions stipulated under Rule 7 Sub-Rule 3 of Companies CSR Policy Rules 2014. This position is applicable from 22nd January 2021 and has a prospective effect. Thus, no carry forward shall be allowed for the excess amount spent, if any, in financial years prior to financial year 2020-21.
Okay, sir. Moving further. Sir, can CSR amount be spent by a company for creation or acquisition of a capital asset?
Yes, it can be done. You see, as per Rule 7 Sub-Rule 4 of Companies Corporate Social Responsibility Policy Rules 2014, the CSR amount may be spent by a company for creation or acquisition of a capital asset. But such capital asset shall be held by a company established under Section 8 of the Companies Act, or a registered public trust or registered society having charitable objects and CSR registration number under Sub-Rule 2 of Rule 4, or beneficiaries of the said CSR project in the form of self-help groups, collective entities, or a public authority. But provided that any capital asset created by a company prior to the commencement of company's CSR Policy Amendment Rules 2021 shall, within a period of 180 days from such commencement, comply with the requirement of this rule, which may be extended by a further period of not more than 90 days with the approval of the board based on reasonable justification.
Okay, sir. This brings us to our next query. Sir, if a company is required to comply with Section 135(1) of Companies Act 2013, whether its holding or subsidiary company is also required to comply with Section 135, even if they individually are not required to comply with Section 135?
Good question. Interesting question. No, answer is no, not at all. The compliance with CSR requirement is specific to each company separately. Every company is having separate legal existence. So it is specific to every company separately. So, holding or subsidiary company of a company is not required to comply with CSR provisions unless the holding or subsidiary itself fulfills the eligibility criteria prescribed under section 135(1), and it is also required by law to comply with provisions relating to CSR.
Okay, sir. Sir, I am curious to know what happens if a company to whom section 135 is applicable does not comply with the said provision. Can you tell us any adjudication cases in this matter?
Yes, of course. For this, we will have to go through the relevant case law of Temenos India Private Limited, ROC order dated under section 135 5/2022. In this case, the company had already spent the CSR amount as required under section 135 within the time limit, but it was spent in the center of university industry collaboration, Anna University, which is not a fund specified in Schedule 7 of Companies Act, clarified by MCA Wide General Circular 14/2021 dated 25th August 2021. Later on in the audit, it was pointed out that CSR amount was not spent in the specified fund. The said company then again remitted the unspent amount in PM CARES Fund as specified in Schedule 7 after a period of 1 year. There being a violation, the company and every officer in default was liable to a penalty as specified under the said section. They filed a suo motu application to ROC for adjudication on this matter. In the circumstances, since the company had already spent the CSR amount twice, the ROC, in exercise of the powers vested to him under section 454 1 and 3 of Companies Act, imposed a penalty of nil rupees
Okay.
nil to the company and rupees 2 lakh each on the directors in default. No penalties were imposed on the company because ROC was of the opinion that it may lead to double jeopardy. So it was not levied on the company.
Okay, sir. Now we come to our last segment, that is adjudication of penalties under section 454 of Companies Act 2013. Sir, please tell us any latest case where Registrar of Companies has adjudicated penalties.
You see, I will certainly tell you, under the said section, Registrar of Companies is required to act as adjudicating authority to adjudicate penalty in case of violation of certain section of Companies Act 2013. In the case of JP Solar Automation Private Limited, Registrar of Companies Gujarat, wide order dated 19/6/2023, imposed a penalty of rupees 25,000 on company and rupees 50,000 on director for violation of section 10A 1A of Companies Act 2013 regarding filing of declaration by a director of the company in form INC 20A within a period of 180 days from the date of incorporation of the company.
Okay, sir.
So, thank you, audience. We'll meet again. Bye.